So let's look at these attacks that have occurred over the years. And there's really, quite honestly, way too many. It would take 4 or 5 hours to delineate them. But it is something I wanted to share with you. So I'm going to break it down first into the attacks on our treaty status and our rights by the U.S. courts. Now, you have to keep in mind that in the 19th century, the U.S. Supreme Court was also evolving as an institution. And this notion that the courts would become so dominant as it relates to Indian rights was really kind of a foreign concept. The very early decisions of the U.S. Supreme Court were rooted, dealing with natives, were rooted in this notion that the federal government had the exclusive right to interact with Indian nations. And it's rooted in the Constitution, in the Indian Commerce Clause, as a very essential ingredient that it is only the United States that has the authority to engage in relations, economic, treaty, and political relations with the Indian nations, as opposed to the state governments. And for those of you who are students of American history, you know about the Articles of Confederation, and you know about the foundation of states' rights in the federalism. There was a lot of turmoil in the American government, arguably still to this day, but at least in those early years, figuring out who had the power, the states or the federal government. So the Supreme Court evolved throughout the 19th century, and you have to put this in context, I guess, of also who were native peoples under the law at this time. We had a treaty relationship. And I think to get your head around this, you have to envision native peoples and our nations being perceived much more like Canada or Mexico today. Foreign peoples, foreign nations in relation to the American government. There's a great book I picked up a few years ago that had all the editorials in the New York Times written about native peoples. Because we were the big news, for most of the country's history. And we were treated and thought of in varying ways, ranging from our friends and neighbors to the historical equivalent of Al-Qaeda, frankly, in terms of these terrorist peoples trying to destroy the United States. So the Supreme Court, throughout the 19th century, evolves different doctrines, that are rooted in establishing the power of the United States. What emerges is the plenary power doctrine, that federal law is supreme as it relates to Indian affairs, that you can displace and push away state power in favor of the federal government. And through the 19th century, it evolves doctrines that were called through the Lone Wolf versus Hitchcock case, the treaty abrogation rules, where you can break an Indian treaty regardless of what the treaty says, and there's no recourse against the United States. That's a matter of American law, that you can bend an Indian treaty over your knee and violate it, and there's no recourse. Now, we didn't like that, of course, but it becomes part of American law that these notions exist, because we're not citizens, we're not seen as citizens, we're seen as these foreign nations, these foreign peoples, and the law evolves in a way that becomes very, very problematic. So by the time you start dealing with very specific court cases, and it takes a long time for there to be specific court cases dealing with the Haudenosaunee. Why is that? Well, most folks who have a treaty don't think that the way to protect the treaty rights is to go litigate. And you also have to keep in mind that it wasn't until 1966 that Indian nations could even enter the federal courts without permission of the United States, because we were not viewed as full, legal persons, for that matter. So there comes a storm on these issues, and the first big ones really deal with the Tuscarora Nation and the Seneca Nation, in terms of the government, in particular the state government's need and the federal government's need for land for power projects. The Robert Moses era, the St. Louis Seaway era, the Niagara River Power Project era of the 1950s. And so this is the low point in American policy towards natives. It's called the termination era after World War II. Terminate these Indian tribes. Rip up those treaties. Oh, did we tell you? In 1924 we made you citizens, even though you didn't like it, even though you didn't ask for it. You don't need to be citizens of your own nations. Rip those treaties up. Oh, and we want your land. We want your land because we didn't steal enough of it in the first place. We need it now for our power projects. The courts get involved in these disputes. And for the first time we see our nations really, there were other cases throughout the years, but we start seeing a response rooted in we need to lawyer up. to deal with this. And so the Tuscarora case, the takings case, went all the way to the Supreme Court. And the Supreme Court came down with a rule that said, well, Congress passed a law that said that their lands could be taken, sort of, but because they really can't demonstrate a very clear right to occupy the lands that they're on, we think Congress's intent was enough. We're going to take their land for this project. And a considerable amount of Tuscarora land is taken for the Niagara River Power Project reservoir, causing dislocation and disruption. This is in the heels of an era, as I mentioned, this termination era, where you've got other court cases that say you can take Indian land without paying any compensation at all. It's not viewed as legally meaningful for purposes of the Constitutional Takings Clause. So this is a very a sort of frustrating time, but it's when you start seeing the court cases, you realize, oh my gosh, we're going to lose these. This is a terrible thing. Termination era, judicial plenary power, you've got lots of power, money behind the governments. How are we going to survive this? And that's when my nation has to deal with the Kinzua project that emerged in the 1930s as a flood control, ostensibly a flood control project to save Pittsburgh and the downstream communities on the Ohio, the Allegheny River, from flooding. This thing was being concocted for decades before our leaders really appreciated what was happening. And sure enough, they need 10,000 acres of our Allegheny territory, 1/3 of it, for this reservoir. Well, we entered the courts and we lost. And the government upheld the taking of what became known as a flowage easement, the use of the waters in our lands for purposes of reservoir backup. We didn't really even get paid for that. The government has this notion that all of the water in the entirety of the United States belongs to the United States. And it's called the navigational servitude. And so you can't pay someone to take the navigational servitude because the United States already owns it. We did receive some amount of money for the relocation, but the hundreds of our people who had their homes burned, whose lives were disrupted and dislocated, in express violation of the Canandaigua Treaty, that we were promised that our lands would not be disturbed until we decided to sell them. There was no more naked of a violation, and it stands as the largest land-taking violation by the United States. And this was only 45 years ago. This was not that long ago. And so the 10,000 acres were taken now, not entitled. We still own title to these lands, and it's relevant today because we're in the process of trying to get the hydro facility under our control as one element of the justice of this issue. But I'm just telling you, in terms of the way the law evolves, the courts just go right along with what the government wants, and they ignore what we think the treaty actually means. Another case that came up about almost 20 years ago now dealt with some Mohawks, the Lozors, who thought that the treaty, the free use and enjoyment language in the treaty, meant they didn't have to pay any federal income tax. And there's a whole history about sort of the income tax issues, but never once has the Congress passed a law that said Haudenosaunee people have to pay income tax to the United States. The only way they get there is they say, well, in 1924 we made you all citizens, and the tax code applies to all citizens, so therefore you have to pay too. But expressly there has never been any statement of income tax collection. So that's a glorious case, and I recommend it to you to read it. Lozor versus Commissioner from 1993 was a Third Circuit case because it's a beautiful case. There was a lot of history, there were a lot of experts that were brought in, there was a lot of explanation. The court seems very sympathetic to the treaty rights concept that we did not negotiate for income tax collection on our income. Where did that come from? That was 1913. That was a whole American thing. But the court said, you know, the problem is under American tax law, we presume everyone has to pay tax. And the only way you get out of it is you need a specific exemption. And we know it's impossible for you to have had an exemption in the 1794 Canandaigua Treaty because the tax code didn't exist yet. But, sorry, you lose. Pay. And that's the kind of frustrating violation of our rights that you see. Free use and enjoyment. What does that mean? Seems to me it means some other government doesn't kind of reach in and take off 15 or 25 or 35% of your income, and if you don't, send you to jail. That doesn't seem quite right as relates to free use and enjoyment. Most recently, we have dealt with American courts dealing with issues of land. The Sherrill case, the Cayuga land claim case, these are cases that are rooted in what's called the Non-Intercourse Act, the Trade and Intercourse Act. One of the very first things that the Congress passed in 1790 was a law that said, no one shall do business with Indians for land without the permission of the United States. No speculators, no state governments. Only the United States, under American law, has authority to acquire and extinguish Indian land title. Well, it seems pretty clear to me what that means, but New York State being New York State, those of you who may think of New York State as a rogue state, it started much sooner than the modern era, goes way back to the beginning, where the state of New York is routinely ignoring the Non-Intercourse Act and entering into land deals with Indian nations. I think most significantly the Oneidas, in terms of the number of agreements that were entered into without the permission of the United States. Every one of those agreements are illegal. They're invalid. They have no force and effect under the law. And the Oneidas started filing suits on this back in the 1970s, early 1970s, just a few years after the federal courts opened up. Well, interestingly enough, the Oneidas started winning, and they win these first couple of rounds. And it's an amazing thing for the Supreme Court to stand on the tiptoes of justice and say, it was a long time ago, but the state violated the Non-Intercourse Act, and so therefore the title remains with the Oneidas. Now there's this little issue, there's a good number of non-Indians living on their land, and they've established civil society and government. What do we do with them? How does that get addressed? So the most recent cases deal with the efforts of the Oneidas to buy back their own land, thereby extinguishing the non-Indian occupant. If you get paid for your land in America, you get to move to Florida, I guess. That seems to be what a lot of New Yorkers do. They get out of the state. Well, if you're buying land within the Oneida or the Cayuga, original reservation, the Oneida took the view, and the Cayuga took the view, well, then we have our land back. It's restored to the status that it was way back 200 years ago, because the non-Indian is now gone, and Congress never took that land from us. Makes sense? Wrong. And this is where the Supreme Court eventually says, in the Sherrill case just a few years ago, 2005 I believe it was, sorry, because of the passage of time, we're not going to recognize that you have full sovereignty over your territory. Sorry. And it really chides me, because I had a colleague when I was on the Iowa faculty who said, Porter, we all know that the law, that when someone steals someone else's land, is that you get it back with damages, unless you're an Indian. And I said, no. No, the law is the same for everybody. He says, nope. No, it's not the same. The Indians don't get their land back, and they don't get paid. And that's exactly what the Supreme Court said in the Sherrill case. Yeah, we know that it's yours, but it's been so long, and the disruption would be so great to the non-Indians that we cannot allow your sovereignty to be restored in terms of